Dear friends, this is a judgment delivered by Honorable Justice Bharat Chakraverty in writ petition 8713 of 24. The issue for adjudication, I'm directly going into the subject, more as a interpretative skills for the students is my concern. Here is a case where the petitioner is a librarian and of a very reputed Kalakshetra Foundation Arundel School. And she's a librarian. And she's retiring on at once she completes 60 years of age on 25/5/24. 25/5/24. When the academic year starts, 1st April, let us say. So the normal bylaws are that whenever the academic period starts, your retirement falls during the academic year. You are allowed to continue and complete that academic year. So the 1st May, then you are allowed to continue till the next session, till that session, if you are a teaching staff. But she was terminated, she was asked to retire. So she took a stand that you are already 16 people are done, list she is given. So it is nothing but a hostile discrimination. Article 14 is the constitutional or fundamental right that is being tested in this case before their lordships. Now, we are not going to go into the how bylaws were drafted, what is the relevant bylaws. There were bylaws that according to that bylaw, this if you're falling in the middle of the year, then you are allowed to continue. So if that is the law, then you have to follow. It is a right, statutory right. And if somebody violates the statutory right, judicial review is the process by which you are testing the procedure adopted by the executive. That the decision making is given to the executive. Whether the decision making process is done properly or not will be tested by the honorable constitutional courts under the Article 226. So there was a bylaw which gave that power, and later on they have removed that bylaw, repealed. So as on the date, there is no such bylaw. That is one. Then it is to the discretion of the management, and then they'll have to inform. In that situation, whether giving some 16 teachers, teaching staff, continuing that facility for the next full session and not giving is the issue for adjudication. Very senior lawyer, senior counsel Vaige madam appeared, and when the lordships are going to look at the issue, how should a judge will look also you can see, because he's setting precedent. When a constitutional court is going to decide a case, it should stand as a precedent. That means the ratio that is going to test will be very much important. So how we analyzed lordships, you see. First, he wanted to see, is she a regular teaching staff falling under that 16 people who were extended? She's a librarian. She's a librarian. So whether you can equate a teaching staff with librarian per se, with the objective that you wanted to achieve, there should be an excess. What you want to achieve, why you wanted to extend it is because the teacher, I'm a teacher, I'm teaching. Students are accustomed to me. And then you cannot say that continuously you will continue and all. To that extent, when you started the academic session, fairness demands that you continue, so the teachers would have been adjusted to you. That's right. Otherwise, till 100 years, they can continue as teachers. That you cannot equate. There is a rule which you have to retire at 60 years, whatever be the reason. That rule has to be followed. There is no arbitrariness. Somebody is extended, somebody not extended. Second point is, the crux is, had she been one of the 16 teachers teaching staff, there is no discussion. Writ is clearly maintainable. But she is a librarian. So what is the difference between librarian and a teaching staff? Even though the salaries are paid same, emoluments, service conditions are same. So what could the judge would have done? If he's a very liberal judge, can he be liberal? That is another thing in this situation. Rationality is very important for a judgment. So what lordships felt is that, no doubt, service conditions, emoluments are there. But librarian context and a teacher context is different. Teacher is teaching the subject, and that students will get acquainted, comfortability levels are there. So disturbing them, that is the purpose behind enactment. So purposive interpretation. Very good judgment, you understand. And so he came to the conclusion whether the Article 14 is applicable or not. In the aggrieved parties may feel that judge could have given us an opportunity to extend, he's not done it. But they should feel that it is not like that. It is not judges here, it's not like alms and doles he will give. He should go by law. Understand? He is doing a duty of great responsibility with setting precedents. Not whimsically, capriciously like that you cannot do. So perfectly decided this matter, wherein here the question is not compassionate grounds to give a compensation a little more or extend this, that, some violations like that. No, here it is a clear-cut law is setting. And here the law for this adjudication is not about extending. Whether the librarian comes under the teaching staff, even though service conditions are there, and what is the purpose, the nexus, it was decided. It is a good case. So lordships have dismissed that writ petition on these grounds. So it is ultimately, the entire thing has come hostile discrimination, Article 14 violation, because there is no statutory rights for enforcement. Then whether that Article 14 can be interpreted librarian and this is not same. So equality, equals cannot be treated as unequals. So therefore the judgment is well done. And Dr. D. Bharata Chakraverty ji, I appeared before their lordships number of times, almost 40 times, I think so. Lordship was with acting Chief Justice Raja, and then with Sanjay Gangapurwala Chief Justice. He is a very good judge. He is grooming to be one of the best judges. I have been appearing when I started in 2011. Sundaresh sir was like that. And because I appeared before him on constitutional validity, we were testing 4 things they heard. And when I filed a review petition before their lordships, both judges, Chief Justice Gangapurwala, they were so gracious, I explained them what all the mistakes that were there in the judgment. And the greatness of the Bharat Chakravarty ji is he only authored the judgment. He was very appreciative. The entire constitution issues were discussed. He agreed, to be frank, you should have done that to review to the other judges, which we relied upon like that. Point number 1. Second is, he's very kind judge. He will not get angry. High patience. I know 200 cases they were testing every day, and patiently used to, sharp listener. And like Sendil Ramurthy Justice is there, he was hearing the constitutional validity prior to him. They are very fast. The way in which you argue, they listen everything and they will pass it in order. That is the greatest strength of them. So it's a good judgment in my opinion, though the petitioner will feel bad. But judges are not there to persuade others and all. Exactly, the judgment was delivered. That is my opinion.